You need to mediate, so don't be late. Arbitrate to enhance your state. Adjudication is your road to salvation. Hunt ADI is your destination. For dispute resolution, there's only one solution. Hunt ADI.
Welcome back to another episode of No Disputing That. In this episode, I had the pleasure of sitting down with Paul Sills. Paul is a very well-known international commercial arbitrator, mediator and trainer, hailing from New Zealand. I asked Paul at the beginning to give himself a bit of an introduction, so I won't do that now here. Hope you enjoy this. It's really interesting and good for anyone who has got an interest in arbitration and specifically international commercial arbitration. Paul?
G'day, how are you, Greg?
Nice to see you again. Good, I'm good, thanks. Yeah, you?
Yeah, excellent. Very good.
Good. Thanks for coming along today and recording this episode of No Disputing That. Back in season 1, episode 19, I did a podcast recording with Marcus Rutherford about consumer arbitration and how particularly the travel arbitration schemes works, but it was largely around looking at how consumer arbitration works, which is slightly different to how a commercial case would work. And I thought it would be a really good idea to have a conversation with you about commercial arbitration and what really goes on in a commercial arbitration. And please feel free to say whatever you like. Don't keep any secrets.
I was going to say, I'm going to think of which secrets I need to let out.
But before we start, do you want to just say a few words about yourself? Let listeners know who you are, what you do.
Yeah, so I'm Paul Sills. I am with Arbitra International in London, which is a sort of boutique group of practitioners who are working as neutral, so arbitrators, mediators, dispute board members globally. I come from New Zealand, where I've spent most of my career as a barrister and then in later years arbitrating and mediating. Moved to the UK for personal reasons in and around that small thing called COVID. Mm-hmm. But I've been here for a while now and sort of nicely getting established as a full-time neutral, so full-time arbitrator, mediator, dispute board member here in London. Yeah.
Excellent. And from what I know about the ADR scene in New Zealand, certainly in the past, it was always considered to be a little bit more advanced than it is here. Do you think that's still the case?
Yeah, look, I think for a long time, particularly in the mediation scene, that would be very true. I think New Zealand mediators, quite a few of whom have trained up here, with the likes of CETA, etc., were very well considered globally. I think arbitration's probably less so because distance meant that arbitration was typically domestic. And as we know, even from here, a lot of domestic arbitration has always been construction based, and a lot of that now, of course, has moved to the adjudication market. So I think for mediation, yes, although I see that having been levelled, I think the way that mediation is taught globally now is very similar in most of the main jurisdictions, and arbitration as well. So New Zealand was probably ahead on mediation, but I think not now. Although some of the practices, the practical way that we mediate in New Zealand, on the day, are probably, I still think, quite good practices. Yeah.
Okay. So before we move on to arbitration, that's quite interesting. Do you want to give me an example of how it differs on the day in New Zealand to how we do it here?
I think my perception here is there's much more of a trend towards that, what I would call the American model of really hiding from joint meetings and parties being quite comfortable, particularly commercial parties, to sort of slip quietly into separate rooms and spend the day on shuttle negotiation. Whereas I think we see a bit more benefit, and a typical mediation in New Zealand, commercial mediation, would start with a reasonably lengthy joint session. And I think it has, as long as it's managed well, as long as you've anticipated any potential problems, I think it has real benefit later in the day to be able to have had that, for the parties to literally have seen the whites of each other's eyes, and often to bring them back into joint session when things are stuck later in the day. So I see that. I still prefer that style, and I see a little bit less of that here.
Yeah. No, I agree with that, and I think when we teach mediation, it's quite often, right, this is your opening session. Of course, when you teach, it's within time scales you've got to stick to because you've only got time limits. But it tends to be opening session, then you split into private sessions. I always say to students, if the reality is, I try to keep the parties together as long as possible in that opening session. It doesn't always work that way, but try and keep them together as long as possible. And then you identify a natural point where it's clear that actually you've done as much as you can do now with everyone in the same room, and now it's time to split.
Yeah, and look, that's very much my style, and I think there's always an organic point where where it's obvious that it's time to break, and often time it with a natural break, so it's a natural move from there into a cup of coffee and then into separate rooms to sort of start that phase. But I'm like you, if the parties are willing to sit there and talk to each other face to face all day, I'll do that every day of the week.
Yeah. And of course, that's the way in the rest of Europe it's been done traditionally. I remember going to conferences in Europe and them laughing at the way we do it, and why don't you keep people together for longer? It's much more effective. Yeah. And our way seems to be a little bit sometimes get the opening session done, rush, get them into the private rooms, and then we can start the mediation. Where actually the mediation starts.
Yeah, and for me that's built up on this focus on a one-day mediation, the focus of mediation as being part of the toolkit for a litigated dispute. So I can see where it's come from, but I just think when you move more and more into some of the big existential issues like climate and stuff, where mediation will have a big role to play, parties have to be engaged. You've got to build consensus around a table. You can't build consensus in separate rooms.
Yeah.
You can negotiate a settlement, which is really all that you're doing. We call it mediation, but it's a settlement negotiation most of the time. You can do that in separate rooms. You can't build long-term settlement and resolution plans on how you're going to deal with limited water supply or something like that in separate rooms. Parties are going to have to get used to engaging long-term face-to-face, which will be a very different dynamic.
Yeah. And I think that comes down to, at the end of the day, making sure as a mediator, the mediator's got all the right skills to help the parties to have whatever format they need for that mediation, rather than saying, this is the way it's done and I'm sticking to this way.
And that will be, I think, one of the challenges, because a lot of mediation training is focused on that one-day mediation model, and I understand why, because it's a product that you can teach, and it's a framework that gives people comfort when they're starting out as a mediator. But a lot of what I think we will be doing or ought to be doing moving forward is far more off the cuff than that.
Yeah.
It's a very unscripted space.
Yeah.
I mean, there's models for it. There's models at MIT and consensus building models, of course. But your skill set as a mediator needs to be far more dynamic than if you've got half a dozen one-day mediations under your belt.
Yeah, I agree. Well, I like being off the cuff, so let's move swiftly onto arbitration. Now, as I said earlier, we did an episode on consumer arbitration, around travel arbitration, and we looked at the sort of things a consumer needs to do to make sure that they've got the best chance possible to have some success in an arbitration, and what a business would need to do if they were in dispute with a consumer. Now that, although the process is largely the same regardless of whether it's a consumer arbitration or a business arbitration, there are some very big differences, and that's why I wanted you here today, really, to sort of talk us through. You've done both, so you've done the documents only, you've done the consumer ones, but you've also done a lot of international arbitration, commercial arbitration. So what do you think is the main, or are the main differences between the two? First of all, as an arbitrator. Yeah,
well, one of the key differences I think between the two is when you're doing consumer arbitration, as you would have talked about on that podcast, there's those extra layers of protection that sit there in the framework for a consumer. And I think as arbitrator, you are always conscious of while balancing natural justice and giving everybody an equal opportunity, you're always conscious to ensure that the consumer gets their fair say and their fair go. So you're probably a little bit more conscious of, their opportunity to put their paperwork in, and probably a little bit more lenient if they're late or confused, etc. Just to ensure that the product you produce, the award, is as enforceable and as stickable and as fair as possible, so that when a consumer who is not used to that being in dispute reads it, they can really understand why you have decided what you're doing and where you've gotten to. And that, of course, all translates into commercial, but typically in commercial, not always, you've got a far more level playing field in terms of the balance of power. You don't see all the time that big imbalance of institutional power versus consumer doing it for the first time. So typically, if people are well represented, you're a lot more relaxed about the process of getting to a hearing and then getting the product, the award, out the door.
Okay, so let's run through a typical scenario. You're appointed today as an arbitrator, dispute between a business in the UK and a business in Spain. What's the first thing you do?
Well, first thing is obviously a pretty thorough conflicts check, and in this day and age that will include, depending on the identity of the parties, a sanctions check to ensure that you're not caught by any sanctions regimes. But so assume both of those are clear and you agree to be appointed. So the first thing is really, it depends on whether it's going to be an institutional arbitration or an ad hoc arbitration. So, without the benefit of running it through the LCIA rules or the ICC rules or similar, is to really ascertain that, because that will govern a lot of the procedural steps and the powers that you have, the influence that you have as an arbitrator as you build up the case. So if you're doing something through an institution, typically a lot of the rules that might sit within your national legislation, the Arbitration Act, a lot of them have been subsumed or tailored by the rules of, say, the LCIA here. So that's very much the first step. Who am I working with? Am I just working with the parties, or do I have an institution that I need to abide by their rules? Which can be great, of course, as an arbitrator, because often they will take care of things like fees. And your fees will be set on a formula, they will be paid into the institution and run by the institution. So, there's benefits both ways, really. Yeah. So that's the first step for me. Second step, or as part of that, you're looking at, well, okay, it's international, so where's my seat? What law am I applying? Am I comfortable with that law? Is it common law or is it civil? And sort of getting your head around perhaps some of the expectations you'll see from the parties if they are from different jurisdictions with different processes. So if they've got, one of them's civil law based and one's common law based, will that be a factor in the arbitration? Because often it's not, because international arbitration tends to blend those two different jurisdictional approaches together. But it is a factor.
Yeah. So in cases where it's a joint application, do you find things like what law and jurisdiction have been sorted out before you've been appointed?
Yeah, look, typically, we spend a lot of time, whether you're sort of learning arbitration or teaching arbitration, looking at the quirks of, the law of the seat, how do you determine it, the governing law of the main contract, the governing law of the arbitration agreement, and all these things. Ideally, you'll pick up a document that, you'll pick up a reasonably well drafted arbitration agreement within the body of a construction contract, for example, and all of that spelt out, so you can go through and go, great, we've got no issues there. But jurisdictional challenges come along. I've done, a few recently, so it's not always plain sailing in those early days.
Yeah. And do you find in the sort of international field, you're always dealing with lawyers, or is it ever just the parties representing themselves?
No, surprisingly no. I've got ones on at the moment that are pretty hefty, construction disputes overseas and one of the parties is represented by their in-house counsel. And again, that adds a very different layer of concerns, considerations when you are moving procedurally through to get ready to a hearing. To ensure everyone has a fair opportunity to put their case and what that might mean and what levels of explanation you might need to go to at your procedural conferences and stuff to make sure everybody's moving forward relatively at the same pace. There's limits to that because there's limits to how much you can hold hands, and you've got to be careful about that. But it does play on your mind. So surprisingly, you will see even really, really big international work with either perhaps not ideal representation, law firms that are new to international arbitration and what that might look like and feel like, or an absence of representation.
And one of the big differences between the consumer field and what you're talking about now is the hearing, because there is no hearing in a consumer arbitration. It's all done by documents. So getting to the point of the hearing in a commercial case, presumably you have the claim, you have the defence, you issue directions, you get more information, and then you have the hearing? Or does it not always work in that sort of order?
Ideally, yes. And there's sort of different styles to how parties will present their information, again, depending on what jurisdiction they're used to. So whether they present it by way of a more traditional sort of statement of claim and defence, or whether they present it by the memorial style, which is a lot more, easiest way to describe it is front-end loaded, so you get huge quantities of information at the time of filing. It's not just a statement of claim, it's a very detailed explanation of the claim, really written submissions supported by evidence, supported by documents. So very, very document heavy. Very lengthy submissions is quite the norm in the international field. So depends on the style, but yes, ideally and very simply, exchange of views on a claim, defence and counterclaim. Any additional disclosure requests, not as never-ending as discovery in the common law court sense, but can be quite detailed. But parties in international arbitration, particularly if they're well represented, are very astute at knowing what they need to see. So you get some very sensible, limited arbitration, disclosure requests, exchange of that, and then a timetable, pre-hearing submissions, post-hearing submissions, cost submissions. So that would be the ideal and the typical process where there is a hearing. And often, even if there isn't a hearing, you'll run through that same sort of process in terms of, as I said, exchange of claim, defence, counterclaim, additional disclosure, pre-hearing submissions, an exchange of submissions, cost submissions, award.
So how would you decide where the hearing is going to be if it's an international dispute?
Often the parties will work that out. Of course, we're always in their hands. Often the assumption is it's going to be at the seat, but post-COVID in particular, that's a much more flexible decision than it used to be. Whether it's going to be remote, partly remote, whether the parties and the tribunal will be in person and the key witnesses will be remote. So there's quite a bit more dynamics around location.
Does it depend how many people are involved in the hearing, or is it just literally on what the parties want on that particular case?
Look, it's a bit of both. It's a bit of both. And tactics, of course. Parties may want to try and force the other side, to have it at the seat if that's convenient to them and all their witnesses flying in and spending money and time. So that, tactics still occur, but it's just, there's more flexibility. I think post-COVID, everyone's a bit more relaxed about doing things online.
And as an arbitrator, do you have a preference?
Not particularly. I actually have a stronger preference, if I put my mediation hat on I have a stronger preference to be in person when I'm mediating. I don't see as much need in arbitration because it is reasonably rare that, you know, the credibility or the cross-examination of, a witness is so critical to a case that everyone needs to be sitting eyeballing each other in the same room.
Yeah.
And in fact, you can talk to people, and I have a lot around the globe, even a lot of senior judges about it, and some of them have a much stronger preference to do things online. They feel they get a better engagement or understanding from the witness. I think partly because some of them are older and perhaps short-sighted, so they can actually see people better on a screen.
Yeah.
So I think it's a bit more neutral than, you know, some people would probably promote. And I certainly think in arbitration we are doing far more and ought to be doing far more of our procedural work, and even our you know, some of the, you know, big procedural fights you might get along the way, doing them remotely.
Okay.
So the whole, I think in balance, international arbitration has got slightly more cost effective and slightly easier to align diaries and things because we are doing more online. So I've got, you know, a lot of work, for example, at the moment in the Middle East, and I'll go out for the hearings. Everything else I'm doing from London. That's pretty typical now.
Yeah. And so what actually happens at hearing? Because I think a lot of people will know that there are hearings in arbitration, but they won't really know what that means.
Look, yeah, in simple terms, because we've all watched too many crime shows and too many courtroom dramas on TV, it's not dissimilar to what you would see in a commercial case in court. Of, you know, not a criminal case, because they're the ones that always make good TV dramas. So similar to a court case, you know, the parties are dealing with their opening submissions, that they are cross-examining witnesses, both of fact and expert. Typically, it's a bit more collaborative, if I can put it that way, because often we would have done a lot more work leading up to the hearing, say if there's experts, on trying to really narrow down the points of difference between the experts, so that when we are in the hearing, we're very much focused on those areas of disagreement, you know, and things like hot tubbing experts, where you sort of sit them together and everybody asks them questions in a sequence. It occurs in court, but it occurs very often in arbitration. So I guess the hearing is a bit more focused around, ideally, the parties working together. So you're still going to cross-examine and you're still going to put people on the spot, but a bit more focus around the parties and their witnesses working to assist the tribunal in getting to the position the tribunal needs to write an award. So it should be, in theory, and often is in practice, a more collaborative, slightly less rigorous or formalistic approach as you would have in a court case of a similar nature.
Right, okay. And the word you've mentioned a few times there, which listeners might not be sort of too aware of, is tribunal. By that you mean the arbitrator or the panel of arbitrators?
Typically tribunal. So often on international stuff, but not always, there will be three. And, you know, you'll always refer to that as the panel of arbitrators or the tribunal. But you also, you know, you have sole arbitrator appointments as well, and often that determinator, if you've got a institution involved, will be about what's the monetary value of the claim, because some of them will have a default rule where below a certain dollar value they'll appoint a sole arbitrator, and above that they'll appoint three, which is, I understand it, but as you all know, the quantum doesn't establish the difficulty or the complexity of a case. So you can have cases that are not worth a much, to, you know, looking at the face value of the claim, worth an awful lot to the party and are incredibly complex.
Yeah, I think it's one thing you learn from working in this sort of sector, this business, is that money is actually just a number. It's so relative to the people involved in the dispute. You know, you can have a huge multi-million-pound case that's relatively easy to settle. We're talking now as a mediator, and you can have a case that's worth £10,000 that is really, really hard and no one's moving and you're deadlocked, and you just can't get them over the line.
Yeah, and to a degree, as an arbitrator, you're conscious of the quantum, but you've also, in many respects, got to put it to one side and not worry about it, because the quantum of some of these international claims can be pretty significant, and if you focus on that and worry about it, I think you lead yourself astray procedurally. You've got to focus on high quality procedure and a high quality process in drafting your award. And for me, the quantum and where the numbers fall is just a part of the exercise.
Yeah. And when you said about a tribunal, sometimes it's 3. What's the dynamics there? How are the 3 appointed, and is there a chief? Yeah,
so typically in that scenario, it will be this way, and it will be within the arbitration agreement or contract between the parties. We say arbitration contract or agreement, really often it's a clause or two within a main contract. So that will typically provide for the 2 parties to the contract to be able to appoint a party-appointed arbitrator, which instantly, sort of in the mind of people who don't understand the process, raises questions of partiality and bias.
Yeah.
But of course you're not. If I'm appointed by a party, that doesn't mean I have to run around and find all the evidence that suits that party, although occasionally, unfortunately, it does happen. It just simply means that both parties have a chance to appoint someone that they know or respect or like working with. And there's limitations around that. If you got appointed by the same law firm 20 times in a row, you're going to get challenged on not being impartial.
Yeah.
Simply, if they're a high percentage of your annual income, sort of thing. So,
all barristers' chambers appointed.
All barristers' chambers,
from the same chambers.
So all of that, and that's always hotly a debated topic around the world. So each party will appoint their own, and they have within the confines of the national law, they have an absolute ability to appoint who they want to appoint. And then typically those 2 will appoint a chairperson. So you will consult with the parties, but it's a decision between the 2, and then so there will be a chairperson on that tribunal, who typically, it is understood, it will be the one who will physically draft the award, although often it might be one of the party appointees because they're not as busy, or you might write separate parts and bring it together, etc. So yes, on a panel of 3 there's a chair. Often if you're dealing with institutional rules, those rules will say things like the chair arbitrator, or presiding arbitrator as they're often called, can make procedural decisions. So you don't have to have all 3 of you conferring all the time for timetabling orders. Right. Typically you do, but you don't have to, and typically the presiding arbitrator will sign off the procedural directions, as opposed to having all 3 of you sign off, for example. So yeah, and that's the very typical way. If the parties get stuck, there's normally a recourse. So if you're working with an institution or under institutional rules, the institution will have a power of appointment. So, and if you're doing ad hoc, then the national arbitration legislation will typically have an appointment process by application to the court. The idea there being is that parties can't hold up the progress of the arbitration by failing to appoint a presiding arbitrator. And typically, of course, it's respondents. Respondents, like defendants in court, want to slow everything down. So there's those procedural rules are always there in place to assist the assist in getting a tribunal up and running.
Okay. And one of the things we say in consumer arbitration is the arbitrator's not an investigator. They can only base the decision, write the award based on the information that's been given to them by the parties. Is that the same?
Yeah, 100%. It's a constant point of debate, because there's always this debate about subject matter expertise as an arbitrator. And that debate, understandable, can be problematic, because you've got to be very clear as parties, if you want a subject matter expert as an arbitrator, are you asking them to make a decision including their own expertise and their own knowledge of the subject matter, or are you simply wanting them to be there as a subject matter expert because it helps with streamlining the process and understanding the complex matters and typically, all the abbreviations and acronyms and things that come out of any industry. And I had that debate a lot. And for example, there's a new aviation arbitration centre in The Hague, and they're very keen on subject matter expertise because the aviation market, particularly the leasing and financing and things, are very tightly held, very very intricate industries. And so they naturally go, well, we want a subject matter expert to be an arbitrator. And I'm like, well, okay, but what do you want them to do? Because the fallback rule, the natural justice rule, is the same as the consumer one. I'm only there to make a decision on what the parties give me. If I want to raise anything else, I have an obligation to put it to the parties and give the parties the opportunity to comment. And that will occasionally happen, but if you want a guaranteed way of getting an award kicked out at court, write it based on something the parties haven't adduced you on, and then give it to them and see how long your award lasts. So it's the same. That framework is one of one of the protection measures in arbitration, whether it's investor state, international, commercial, consumer.
Excellent. So you've had the hearing. You've got all the information you need. Now it's time to sit down and write the award. So what process are you going through there?
Look, I'll start by saying this. I try to follow a very similar process, whether I'm doing something small on the papers or something really large, post a hearing. And the reason I do that is because I use that process to help me formulate what the outcome should be. So I have my ideas of what I think it's heading to, but I very deliberately don't make those decisions until I've written the first comprehensive draft of the award, because that process to me is that process of synthesizing the information to come to a conclusion. So I have a very formulaic, if you like, way of drafting, because as I do, I'm going through all the evidence, and so the only difference between, say, a small consumer job on the papers and doing it post a hearing is just the volume of what I'm going through. The process for me doesn't change, and I actually think shouldn't change, because I need to be as comfortable signing my name to that consumer one as I need to be signing it to the £500 million one, for want of an example. And if I follow the same process, then I get to the same position and degree of comfort in doing so regardless of the size of the claim. It just takes a lot longer.
I mean, one of the criticisms over the years of commercial arbitration has been the amount of time it can take. But when you sort of think about everything you've said, all the documentation you've had in the first instance, any responses, any hearings, all the other information, there's a lot of information for you to consider.
So if you take, a lot of international stuff is, construction or energy based, a lot of commercial and stuff as well. But if you think of a typical sort of construction arbitration, you might have literally gigabytes of data having come into you in terms of critical path analysis and plans and things. You might have half a dozen experts on each side dealing with quantum and delay and various aspects of how this is all sliced and diced. You might have had 3 weeks of hearings. My rule of thumb, probably many arbitrators' rule of thumb, is if my hearing's been 3 weeks, it will take me 3 times as long, if not longer, of full-time work to write the award. So, you can be talking about 3 months of doing nothing else, full-time work, to produce, an award on a pretty big piece of work. So, that criticism, I think, is reasonably well founded, but also is an enormous amount of effort that goes into these things. And so it takes a long time. I think the arbitration market is getting better at addressing it. So, for example, with Arbitra, the management team are pretty strict on us taking on more work if they know we should be spending that next 3 months writing an award.
Yeah.
And will lean on us very heavily to produce it in that period, and for that very reason. And of course, if you're doing an institutional arbitration, most of them have timing requirements anyway. I mean, you can slide them, and stuff, but everyone nowadays is a lot more conscious of turnaround time.
And if it's a tribunal of 3, what happens if one of them isn't pulling the weight or is always delaying things? Can the other 2... Do you have to have sign-off from all 3 arbitrators on the panel?
Most national laws will allow for a majority decision, and you don't even typically need to have a dissenting opinion. Often the dissenter will write it because they're not happy with particular points or directions taken by the majority. But in theory, most of the time, you can get 2 to sign off, and that's an enforceable award. Yeah. And there's also, again, most national legislation will provide or recognise an ability if the third person is just dragging their heels because they are actually being partial and undisclosed, are aligned with the interests of the party who appoint them, and think that's, you can often get an award out even if they're never going to, they're not even going to dissent, and they just stop working. Yeah. So there's reasonable safeguards around that.
And is there still such a thing as an interim award?
That sort of terminology is not used anymore, because the whole idea of an award, and this is a constantly debated point in arbitration semantics, is orders and awards. So an order, in very simple terms, is something procedural that we want the parties to do, and the idea being that it's not enforceable in court or globally under the New York Convention, and it's not a final answer to something. So the typical terminology is partial award and final award. So yes, you can do a lot of partial awards. Example, I've got an arbitration at the moment where we've already written 2 partial awards. So one on jurisdiction, because one of the parties challenged our jurisdiction, and one on partial payment. So so the terminology is partial and final. So because it's really important, because awards are enforceable in court. They're enforceable internationally if you're a signatory to the New York Convention. So getting the distinction right is really important. And a partial award, really simply, is just a final answer on a particular point.
So
you don't revisit that point.
Right.
Yeah.
But do they become part of the final award, or are they just done and dusted, and then you have the final
Separate.
Award?
Separate. Yeah. So then you're doing a final award on everything else. So you might do a partial award quite typically on a challenge to jurisdiction. You lock that in. They can be challenged in court. I've had that occur, but then that's the answer on that point. You get on with the rest of it. Okay. You don't sweep them all back into there's not one final award that takes everything. And some of the very big international stuff, it's not uncommon to have 2, 3. I think I saw one case with 8 partial awards over 4 years, because the parties are fighting hammer and tong. Yeah.
And I suppose then the sort of final step is if one of the parties isn't happy with the award.
Yeah, so the whole framework of international commercial arbitration is this idea of speed and finality. So, one of the things parties need to understand going into arbitration is that they are voluntarily limiting their rights of appeal and challenge. So they don't have that layer, that structure that they benefit from in the court system. Court of first instance, Court of Appeal, Supreme Court here. So the rights of challenge are very limited, and internationally those rights of challenge are frameworked in the New York Convention. and there's 5 or 6 grounds of very specific points that you can challenge an award on. The whole idea being, international arbitration works because of the New York Convention and because of enforceability. So leaving enforceability or challenges to an award open-ended destroys that framework. So in national legislation, you'll find very limited grounds. In the UK Act, sections 67, 68 and 69, 3 sections dealing with challenges to awards. Other than that, it's enforceable, and they're pretty hard to get home on.
Yeah.
By and large, similar thinking, not the similar wording, but similar thinking in the framework of the New York Convention in terms of what you can challenge an international award on. A couple of open-ended spots when talking about public policy, so it's a bit of an inroad for national courts where awards are being enforced to, play around with public policy. And if the courts are in the pocket of the political regime, for example, you might get some reasonably interesting decisions on public policy. But by and large, once an award is rendered, unless it's an obvious error, and that's typically needs to be an error of law, not an error of fact, that's your gig. So selection of your arbitrator, your tribunal is incredibly important, because often once they're appointed, it's their outcome.
Yeah. So you mentioned the New York Convention a couple of times there, and there's 120, 130 countries?
No, 100, I think 173.
Oh wow.
Yeah.
Yeah, so that's most.
Yeah, so I have looked at this before, but I think depending on how you define countries, there's about 207. So the overwhelming majority of countries have signed the New York Convention.
And that means that an award can be enforced automatically in any of those countries?
Yeah, it means that all the signatory countries are meant to treat awards the same way and to enforce awards the same way.
Yeah, as if it had been a decision made in that country.
Yeah.
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 Okay.
And that really has been the success story of arbitration internationally.
Yeah.
And why it is the preferred option for business for a whole bunch of reasons, but confidentiality and all those being a part of it, but also global enforceability. It's far better than trying to enforce through national courts, which is it's a far more complicated regime.
Yeah, I think for me that's always been my preferred advantage of international arbitration is the whole fact of enforceability. And if you were to take legal action, you might have to do it in several different countries, but you can do it by arbitration once.
Yeah, and you can enforce in several different countries,
and
parties do, and chase assets around the world. It is, if you're looking for a defining feature and the reason for the success of international arbitration, I think it's pretty well accepted, and certainly it is for me, it's the New York Convention.
Yeah. Excellent. Anything else you wanted to add that I've not asked you about on this? Any funny stories about anything that's happened in a arbitration that you can share?
Yeah, lots. I think the reality is you'll do some international arbitrations that just are easy from beginning to end in terms of the dynamics of the parties and their representatives, agreements. Most everything they agree to in terms of exchange disclosed information and things. You get to the hearing, having had at times not a great deal to deal with the parties because you've had 2 or 3 procedural conferences. They've kind of delivered everything on a plate and off you go at the hearing sort of thing. Others, of which I've had a few, the parties are fighting from day one. Yeah. And you're writing procedural orders every second week. They are a real slog through to the hearing. So you never quite know what you're going to get.
Yeah.
And it's never, it's a mistake to assume, it's another construction arbitration that looks like X, Y, Z.
Yeah.
Same as a mediation.
Yeah.
You fail the day you think, I've done dozens of these, so I know what's going to happen here. You don't. And arbitration's exactly the same.
Yeah.
More guidelines, it sort of sits between the civil procedural rules and the flexibility of mediation in terms of guidelines for structure and enforceability and stuff. So it's a fairly party autonomous, fairly loose process. So within that, you can get a lot of wriggle, and that makes it quite entertaining.
Do you ever get any arbitrations stopping so they can go off and mediate?
Starting to see, yes, and starting to see more of that. Even on international, even investor state, even big stuff globally with the likes of the ICC, I am seeing more frequently, or arbitrators are saying to me, I'm saying, how are you going on that? And they say, well, it's parked because they've gone off for 3 months to settle. So, and I think that will increase, and I think it should increase. So, yeah.
Final question. Is AI a threat for arbitration or an opportunity, or both?
Far more opportunity for me. We do with AI what we typically do with all these things, and we rush to the end game and go, oh my gosh. And we did it with the fax and email and the internet and everything else that people with grey hair like you and I have been through in our practices.
It's very kind of you.
I know.
Her,
I know. And the reality is, it's not that.
Yeah.
It's an opportunity to do things differently. It's an opportunity for smaller participants to get a more level playing field, because they can use AI to enhance their research, their drafting, their processing around arbitration and mediation. So no, for me it's much more of how do we bring this into practice, not I'm going to be out of a job. I'm not going to be out of a job. You're not going to be out of a job. That's the reality. And if we are out of a job from AI, it's going to be long after I've gone. So for me, it's opportunity, and I think the timing globally is really important, because we are facing, I don't over dramatise it, but we are facing threats of an existential nature that we haven't necessarily seen before. And so quite frankly, when it comes to climate and climate mitigation, we need all the assistance we can get. And if a chunk of that's going to come from technology, which I think it is, then let's just get on with it. So no, I'm trying to learn as much about AI as possible, not to stave off the inevitable of I'll be an old man retired and pottering in the back shed. Nonsense. It's just to stay. It's just how we building this into our practices.
Yeah, I agree. I see it as a huge opportunity.
Yeah. And people say, AI is going to do people out of a job. No. AI is going to render redundant over time people who are not prepared to embrace technology.
It's going to give people a lot of jobs.
Yeah.
By its very nature, it's going to create jobs.
Yeah.
I think, but I keep saying to my kids, I know you're not allowed to use AI for your university studies, but on the side, can you take an interest in it and start learning about it, because it's going to be such an important part of, an integral part of your careers.
Exactly right. We have to, and jurisdictions are starting to deal with, courts and others starting to deal with the reality of integration of AI. It's a disclosure issue, really. Disclose when you used it, and it's the onus is on the humans to double check it. And there's a really funny story of New York lawyers putting in submissions to court, done by AI, ChatGPT, I think, but the platform doesn't matter. Not checked by them, 5 fictitious cases, so they got sanctioned and I think fined. So there's those lessons, but a lot of courts, Ontario, state courts in the US, New Zealand, others have all now got AI protocols in place. So basically saying if you're going to use it, here's your disclosure requirements to the court and to the parties. Silicon Valley Arbitration Centre, which is very much focused on tech disputes, have got a draft set of arbitration rules in and around the use of AI up and running for circulation for comment. So we're going to deal with it like we deal with all the time. But everyone's just got to stop and breathe and go, right, how do we use this? How does it apply to what I'm doing? How do we factor this into our practice? No, other than, if we're going to say a summary, arbitration, works on a very, I think, well-defined framework. Whether that's a consumer one with its extra layers of protection, that is typically on the documents, or whether it's your very top end investor state arbitration, where there's £10 billion at stake. The functionality of the process is by and large the same. It's just the expected layers of complexity that you will go through procedurally, and the length of hearing and the length of time to write these awards and stuff. That's really where it changes. The grassroots process and fundamentals of party autonomy, fair opportunity to present your case and things, they exist from the very smallest to the very biggest. So in that respect, it's really nice. I think it's a really well tested, very uniform framework, I think, which works really, really well.
Great, and on that summary, good time to end. Thanks very much, Paul. Really appreciate that.
Pleasure, anytime.
Enjoyed it. Thanks,
Greg.
And now over to George to play us out.
You need to mediate, so don't be late. Arbitrate to enhance your state. Adjudication is your road to salvation. Hunt ADI is your destination. He's working from home. Yeah, he's working from home. For dispute resolution, there's only one solution. Hunt ADI.